The Justice Department has asked a federal court for an emergency order to block Texas's abortion law. So this morning we're going in depth on the law and about how it could impact abortion rights in America. Many worry that it could be just the first step towards an outright onslaught against abortion rights and access in America. Chloe Nordquist sat down with law experts to discuss what makes this effort different from previous ones.
Texas passed a law that bans abortions after a heartbeat can be detected, usually around 6 weeks of pregnancy.
This law is different. For the most part, it tries to adopt a relatively strict or restrictive approach to abortion policy.
The law also allows any person to sue anyone who helps a woman get an abortion after that time, from the provider to the driver who brought her there.
The key difference here among the Texas bill as opposed to other laws is that instead of the enforcement mechanism being the state, now you allow the citizens to actually sue in civil court to prevent that abortion.
Political science professor Robert Preuss says when states have pushed further restrictions on abortion in the past, the biggest blockage has been the Supreme Court, because the abortion seeker or provider can sue the state. However, with this law, that's not the case.
This new law from Texas has a unique way of approaching enforcement, and so therefore it's still up in the air exactly how far the Supreme Court will let this stand. So far it has.
We've seen other abortion statutes that authorize private individuals to sue, but we've never seen anything that allows quite literally anyone to sue.
Mary Ziegler is the author of multiple books on abortion.
It does seem that the federal government has limited options to change what's going on in the ground in Texas.
She says the Texas law is more difficult to challenge.
There's no state actor you can sue. And to bring a constitutional challenge, you can't sue a private citizen because the Constitution only gives you rights against the government. So then it creates a catch-22.
Constitution law expert Ernest Young says those fighting the Texas law will have to find a different way. The Department of Justice's lawsuit is one possibility.
Once the law is actually challenged in a posture where a court can rule on the merits, that would raise as one of the issues whether the court is going to continue to follow Roe versus Wade.
Roe versus Wade currently gives pregnant women the choice to have an abortion without excessive government restriction.
The most interesting things are likely to happen in those state court lawsuits as they progress.
Robert says what happens in Texas will be a big indicator of what we could see elsewhere.
If this law does stand a constitutional test, then you will see Republican-held governments, state governments adopting further restrictions and probably modeling those restrictions on something very similar to Texas.
The Supreme Court hasn't allowed a law like this since the ruling on Roe versus Wade, but later this year, the High Court is also expected to hear a case from Mississippi on a law that would ban abortion at 15 weeks. That decision could also affect abortion laws across the country.
If the Supreme Court wanted to hear this case, that would require the court to either say Roe v. Wade is gone or part of Roe v. Wade is gone, which is to say you can ban at least some abortions before viability. And that's why it's such a major event, because there's no way for the court to uphold this law without either undoing or rewriting what it means to have a right to choose abortion.
We don't really know how this is going to play out.
I'm Chloe Nordquist reporting.
The Texas law is far from the only challenge to abortion rights in America. In fact, the state of Mississippi wants the Supreme Court to overturn Roe v. Wade completely. Earlier this summer, Attorney General Lynn Fitch submitted a brief to the court that claims the decision in Roe v. Wade was egregiously wrong and asks the court to overturn it. That would allow the state's Gestational Age Act to take effect. The law bans abortion after 15 weeks and has no exceptions for rape or incest. It was passed in 2018 but hasn't taken effect because of a pair of lower court rulings against it. For some more depth on the issue, let's now look at our own abortion laws and how they compare. According to the pro-choice nonprofit NARAL, Colorado has some of the least restrictive abortion laws in the country. Our state is one of only a few where you can get a late-term abortion. Our law allows for abortion procedures up to 26 weeks for most pregnancies and 34 weeks for fetal anomalies and genetic disorders. Unlike a lot of states, there is no mandatory waiting period either. We know there are plenty of opinions about abortion out there, and we want to hear them all. So let us know what you think. Should abortion access be protected or restricted in this country? Send us your comments to 360@thedenverchannel.com.